Hi, I'm Carl Torsbins, author and maker of the Jodi Arias Son of Sam Laws video. This is based on a request by viewers regarding her attempts to sell merchandise on the internet. Jodi Arias is currently awaiting sentencing, and in the meantime, people are asking, well, how come she gets away with selling her stuff on the internet when in fact she's been convicted of a crime and she should not be eligible to make money off her merchandise? Well, the Son of Sam laws are very, very specific. And because the Son of Sam law is an American law designed to keep criminals from profiting from the publicity of their crimes by selling their stories to publishers, it's not the same as a asset forfeiture, which is intended to seize assets acquired directly as a result of a criminal activity, where assets forfeitures look forward to the profitability of crimes by taking away money and assets gained from the crime. This is the sticking point of what people have to understand when it comes to the Jodi Arias case. Son of Sam laws are designed so that criminals are unable to take advantage of the notoriety of their crimes, and such laws authorize the state to seize money earned from deals such as books, movie biographies, and paid interviews and use it to compensate the criminal victim. There's been much discussion on the Jodi Arias case and her ability to make money from her arts and crafts. She hasn't even begun to write her memoirs, and it's suspected that it's been in the works for some time now, but yet revealed for legal reasons. Many people feel Jodi Arias should not be allowed to profit from a crime and try to apply the Son of Sam laws on her case to restrict her profit-making abilities. Supporters of the law say they help crime victims and prevent criminals from profiting from their misdeeds. Opponents, on the other hand, counter that the law infringes on fundamental First Amendment rights. However, the Son of Sam law has many challenges on the grounds of First Amendment, not just in one case, but in many high-profile cases where the criminals actually published or authored a memoir or a book that revealed their thirst to talk about their crimes. There are currently many states which have Son of Sam laws. Each state has their own language, and Arizona has one too. There is speculation that if challenged at the higher courts, the state will lose, as many others have in the past. The following states, about 34 of them, have not been struck down yet by the Supreme Court. States with active Son of Sam statutes that have not been replaced or struck down by Supreme Courts are Alabama, Alaska, Arizona, Arkansas, Colorado, Connecticut, Delaware, Hawaii, Idaho, Indiana, Iowa, Kansas, Kentucky, Maine, Mississippi, Montana, Nebraska, New Mexico, North Carolina, North Dakota, Ohio, South Dakota, Vermont, Virginia, Washington, West Virginia, Wisconsin, and Wyoming. States that have repealed Son of Sam statutes and then replaced them with modified statutes, which are about 10 of them, are California, Illinois, Maryland, Nevada, New Jersey, New York, Pennsylvania, Tennessee, Texas, and Utah. Now, remember, the New York is the Son of Sam case, which was replaced in 1992. States that left Son of Sam statutes active through state, although still being struck down by the court, Rhode Island. And only one state has never enacted a Son of State statute, and that's New Hampshire. 4 states have repealed Son of Sam statutes without replacing them, and they are Louisiana, Massachusetts, Missouri, and South Carolina. The focus is on the Simon Schuster decision in the Supreme Court. David Berkovich terrorized the city of New York, killing 6 people, injuring 7 others. Berkovich was called the Son of Sam because he claimed that a spirit named Sam told him through a neighbor's dog to murder his victims. He was also referred to himself as Son of Sam in a letter that he wrote at one of the murder scenes. Arrested in August 1977, Berkovich later pleaded guilty and was sentenced to 365 years in prison. After hearing reports that Berkovich was offered a substantial amount of money for the rights of his story, New York Assembly in 1977 passed a law requiring that the accused or convicted criminal income from works describing his crime be deposited in an escrow account. The funds from the escrow account would then be used to reimburse crime victims for harm they had been suffered. This has been called the first series of Son of Sam laws. New York State attempted to enforce the law and were challenged by publisher Simon & Schuster. The case went all the way to the Supreme Court, and the case was eventually struck down by the Supreme Court in 1991 as it violated the First Amendment. The court voted unanimously to strike the law down. They found it imposed a financial burden on speakers because of the content of their speech. The court noted that the law was content-based and because it applied only to works with a particular content. In First Amendment jurisprudence, content-based laws must be justified by a compelling state interest in a narrowly tailored way. The High Court found the state officials had a compelling interest. The High Court also found the state had a compelling interest in preventing criminals from profiting. However, the court determined that the law was too broad or too over-inclusive and that it was defined as a person convicted of a crime to include any person who has voluntarily and intelligently admitted the commission of a crime for which such person is not prosecuted. Arizona found another way to deal with the profit-making, but it did not apply the Son of Sam law because they knew it would be challenged. The approach taken in Arizona, it was a case of Sammy the Bull Gravano, who was targeted for seizures, and through the Arizona Appeals Court, rejected the arguments of State versus Gravano that the Arizona forfeiture statute, unlike Son of Sam law, was not specifically targeted expressive works. What they did was they went through another way. They went through what is called the RICO, or the Racketeer Influence and Corrupt Organization statute. Arizona cleverly went through the RICO law, and I predict that the future of prosecutors finding creative ways around the constitutional problems imposed by the Son of Sam laws will implement cases that do not attack expressive works under the First Amendment protection and pursue RICO statute violations rather than Son of Sam laws. This is why the case has not yet come to head with the legals as far as Jodi Arias' case is concerned. I've attached the law as it writes and as it reads by state statute. I always thank you for watching my videos, and I appreciate it. Thank you.